My name is Eduardo Ayala. I'm managing partner at Ayala Law, and today we're going to talk about construction liens. What is a construction lien? A construction lien is sometimes called a mechanics lien. The very basic definition of a lien is an attachment to property. Mechanics liens or construction liens are liens that protect those who work in houses, those who work in physical, real property, do work there, and then they don't get paid. So the law provides for them to have a security in the property where they did work. So that's the very basic premise here. The work has to have been done for obviously improvement of real property, right? If you made a destruction or you didn't do good work, separate. That's a separate question. But it's generally for improvement. There wasn't a pool and you built a pool. There wasn't a wall and you built a wall. So you have to improve real property. Florida construction lien law, it's regulated under Florida Statutes Chapter 713, Part 1. That's where you find most of these regulations, or the process and procedures for how a lien is created, how a lien is perfected, how a lien is enforced, how construction lien is enforced or created. The first important thing under this entire body of law that you need to know is that there are strict notice requirements that you have to comply with before your lien can be perfected, before you can have a right to fully enforceable lien. You could have a lien, a construction liens against many parties. Remember, in construction, we're dealing not only with an owner or the person paying for the construction, we're dealing with subcontractor, general contractor, subcontractor of subcontractor. There is an entire chain of people that may be entitled to a lien. Even the worker, the laborer may be entitled to a lien if they follow certain conditions. Material man, right? Material man is a fancy word for the supplier. If you actually, sold tile to a home, and your tile, the one you sold, was installed in a property, then you as the material man may be entitled to a lien for not getting paid for the products that were installed in that property. Professional services, if you're an architect, if you're an engineer, if you drew plans, if you're a surveyor, if you drew plans, if you drew a map, your services were used that are a prerequisite. Not everything is physical things in construction. All of these maps drawn or this technical expertise provided by professionals, if they don't get paid, they could get a lien on the property that benefited or that obtained the benefit of that work. The first premise for asserting a lien, claiming a lien on property, is you have to have a contract with the owner of the property. You just don't go there and build things if you don't have some contract relationship with the owner. A contract could be written and sometimes it's not written. It could be an oral contract. Oral contracts are enforceable, though that's subject of a completely separate video or topic. Subcontractor or another person can also have a contract with the owner. Sometimes the owner makes different contracts with the different parties or professionals involved in the building of a project. But also, the subcontractor could have a lien just by having a contract with the other contractor. We'll go in detail as to that. Now, before we dive into that, who does not have entitlement to a construction liens? If you're working on public property, you cannot have a lien on public property pursuant to 713.01 section 27. The government always gets a break. You don't get to put liens when you're working on public property. Persons not in privity with the owner when the owner's contract for improvement is for $2,500 or less. So if you don't have a direct contract with the owner and you're a subcontractor or the contractor or the subcontractor, you're like far removed in the chain of direct access to the owner. So you don't have a right to a lien under Chapter 713. An unlicensed contractor, and this rule is very harsh. You could have literally built the entire home, but if you don't have a license, you don't have a right to a lien. In fact, you may not even have a right to collect at all. So unlicensed contractor, you have to be very careful because the law treats you very harshly. You are not unprotected. It doesn't matter how much effort, how much supplies, how much work you put there. If the owner or whoever doesn't want to pay you, is claiming that you don't have a license, you may have lost all your work, your effort, and your materials. Let's talk about the notice, the pre-lien notice requirement. All lienors, right, who are not in direct contract with the owner must serve a notice to the owner on the real property of the owner under 713.06 section 2A. So if you are not in direct contract, so you're not the person that the owner hired first, right? And you're a subcontractor of that general contractor, you need to give personal notice to the owner of your identity, of the work you did, and of what you intend to put a lien on. You must serve this notice to the owner before commencing or before starting to supply the services or materials. Between the time you start up to 45 days after you start to furnish the services or the labor or the materials, and before the owner makes final payment to the contractor. So that's the time frame that you need to provide your notice to the owner if you're not in direct privity, in direct relationship with the owner. The failure to do this could potentially be fatal. The lien requirement for perfecting liens is very strict. So if you do not meet these requirements, if you serve it after the deadline, you may not be entitled to your lien, and you may have other options, but your options are not going to be collateralized or protected by the actual property where you did the work or where you furnished the materials. After you've given this notice, you must record the claim of lien with the clerk of the court in the county where the real property is located, no later than 90 days after the earlier of 1. The last date that the lienor provided the labor, the services, or material, right? The last day of your work. Or 2. The date of termination of the original contract if terminated before completion. So those are your two deadlines for recording your claim of lien in the county records, in the official county recorder where you record deeds and things like that. The claim of lien must include all the information required by Florida Statute 713.08, right? The description of the property, the debt, the name of the owner, and all these specific requirements. Again, it's a strict compliance statute. If you don't have any of these, potentially your lien could be in jeopardy. Your lien may not be enforceable. And this is something that you're not gonna be able to find out until a year later in litigation. The owner may say, oh, your lien is not compliant, so your lien is not enforceable. So it's important that you comply with these things from the very beginning, that you have a lawyer that make sure that everything is well taken care of. You must then serve the claim of lien on the property owner either before recording or within 15 days after you record this lien. So you either served it before recording, or if you recorded it but the owner doesn't know yet, you must provide a copy of this recorded lien to the owner. It must be personally served on the owner. So this doesn't mean that you scan a copy and then you email it to the owner, you send it via mail, via regular mail. No, it means that you personally serve. You hire what is called a process server, and this process server serves or gives the copy of the recorded or your recorded claim of lien in the hands of the owner or in the hands of an authorized representative of the owner if a corporation. It's the same personal service process that we follow when we file lawsuits, and you have to serve that lawsuit. The claim of lien is potentially voidable if the lienor, if you fail to serve this lien on the property owner within the required day, and the failure of serving this lien within that time period is prejudicial to the owner. Let's say the owner sold the property. Let's say you took a while and the owner already moved on and hired somebody else. I mean, there could be circumstances where you claiming this too late will be prejudicial to the owner, and your failure to notify the owner of this lien, even if you recorded it, could be that the law determines that your lien is void. How do you enforce a lien? You enforce a lien through foreclosure proceedings. In a similar way like bank enforces its mortgage when you don't pay the mortgage. So you file a case in court and the bank will be entitled to foreclose on your property. The foreclosure process is a process that determines that you owe the debt, that you didn't pay it. Then you get a judgment, and as part of a judgment, you are entitled to a sale of the collateral, the house. The construction lien foreclosure process is very similar. You have to start a lawsuit within 1 year though. You recorded your lien, you give your notice to the owner. You cannot sit on this lien for more than a year and then pretend that it's gonna be there, and then on year 2, year 3, or 4 years later that you're gonna be able to foreclose on this lien. If you don't foreclose it within the 1 year from the time the lien was perfected, then you completely forgo that claim of lien. It's no longer valid under Florida Statute 713.22 section 1. You must also record a notice of lease pendants. A lease pendants is a document that it's filed in the context of the foreclosure process, and that gives a notification to the world, a notification to the public that there is litigation pending this asset. There is claim that is directly related to this piece of property. This is done to preserve the priority of other creditors over claims on this property. The property owner may force the lienor, the ones with a claim on lien, to commence the action before the 1 year. Let's say the owner has a claim of lien, is aware of it, has notice of it, but doesn't want to wait to a year until the contractor, the general contractor, files his lawsuit. The property owner can expedite this process by commencing himself a lawsuit within 60 days after the owner serves the lienor, the creditor, what is called a notice of contest. Failure to comply with this extinguishes the construction lien under Florida Statute 713.22 Section 2. So the owner is not without also resources or remedies in order to try to expedite and sort out this situation where someone is claiming an interest in this property. After the owner files this notice of contest, the original contractor must serve a final payment affidavit on the owner at least 5 days before commencing an action to foreclose its construction lien. Other lienors like subcontractors, laborers, or material men, more far away from the chain, do not have to serve the final payment affidavit. Once a foreclosure property is sorted out, and this is a case that could take potentially months or even years sometimes, the lienor received the amount due following the sale of the property as stated in the court's final judgment, and it basically forecloses on that construction lien. The court may also enter what is called a deficiency judgment. A deficiency judgment, it's a judgment for the difference. Let's say you had a lien that you properly gave notice to the owner, that you perfected and that you foreclosed on, and the lien is for $100,000. And let's say the property is worth, at the time of the sale, it was purchased for $80,000. So the court could enter a deficiency judgment, a judgment that will be uncollateralized for the $20,000 that you are still owed because the property was not able to fulfill or to fully pay you back for what you were owed under that lien. That's it regards construction liens, mechanics liens. If you have any questions, leave us in the comment or shoot us an email. Shoot me an email at eduardo@ayalalawpa.com. Contact us at our number 305-570-2208. Follow us in YouTube for more content explaining Florida law.